All right. Good morning, everybody. My name is Dana Sparks. I am the director of the Georgia Real Estate Academy, and this class is the 2021 RE Forms Contract Dissection GREC course number 72957. I've got another computer over to my side, which is why I keep looking. That's where I'm going to monitor the chat. So welcome, everybody. I hope you are in the right place. Couple of housekeeping tips, and then we will dive right in. The way this school, the Georgia Real Estate Academy, tracks your interaction is through the chat function. So if you have not already done so, please type in your name, your license number, your email address in the chat. Make sure it says that it's going to everyone. If you are attending by a phone, which I don't see anybody on here by phone, so that's not an issue. Now, different schools have gotten different things approved through GREC for the virtual transmission of their classes. So some schools I know require that you have a video camera. Again, as long as you can see me, I love seeing your faces because it reminds me of teaching classes actually in the classroom, but the interaction is going to be through the chat. So what you did with your name, your license number, and your email address, you're going to have to do that 3 times total. Now at the beginning, when you come back from break, and then right before you leave. Additionally, I will ask some questions and ask for your answers in the chat function. Sometimes I go a little quickly, so even if I answer the question before you have chance to type it in, go ahead and type in your answer. Again, that's how we gauge and can demonstrate to GREC that you are on the class and still paying attention. You didn't just turn on your computer and walk away for 3 hours, but how could you, right? So again, my name is Dana Sparks. I am the director of the Georgia Real Estate Academy. I am also the broker of Maximum One Greater Atlanta Realtors. The only reason I tell you that is this is a contracts class, and I just wanted to give a little context of my interaction still with contracts. I'm a non-competing broker, meaning I don't interact with the public. I don't help people buy or sell anymore. I just help my agents help people buy and sell, and I manage the company, and then I like teaching. So but I do see contracts on a regular basis. I don't see every contract. We've got a compliance broker that reviews every single contract. I just see the ones where there's questions or issues or interesting things. I'll term it that way. So, you know, I only see a couple a year, right? Anyway, again, I just wanted to give you guys a little bit of context for my current interaction with the contracts. We are one of the few schools that actually does teach a full contracts class on these RE forms, which is what this one is. We also have another class that we enjoy teaching called 2021 Contracts Review. And what that is that is a direct head-to-head comparison and contrast between the RE forms and the GAR forms. So you'll see what the similarities are, what the differences are, and all of those kinds of issues. I think I have it in the slides, but I'm not sure. Handouts, we will email you the handouts. You don't need anything for this actual class. I'm going to go through everything on the class, but I know a lot of people like to have the handouts. So you will get all my handouts with all my underlines and all of that kind of stuff after class. But again, I'm going to go through everything throughout the class. Hang on one second. Okay. Okay. All right. So I do have a PowerPoint, and then I'm going to share my screen and share the PowerPoint. And then I am also going to kind of flip back and forth to show you the forms in and of themselves. When I teach this class in person, I don't go by the PowerPoint. I just have the handouts, and we just go through the actual contracts. I think it's kind of important to see it within the paragraph that we're talking about within the context of the contract. So I'm going to kind of do that a little bit on this class too, just to kind of give you a sense of where things are. All right. Ready to get started? Gonna be a fun class. All right, let me share my screen and we will get going. Share screen. Start with the notice to students. Let me make sure that we're seeing it over here. And let me get my chat. All right. Make this small. Too many icons. There we go. All right. Notice for students for the virtual broadcast of a continuing education class of a GREC approved classroom class. That's a mouthful in and of itself. The Georgia Real Estate Academy, which is this school, it is GREC school number 6915 that will be renewed on December 31st of 2022. Presents the following course of study: 2021 RE Forms Contract Dissection, which is GREC course number 72957. Make this a little bigger for you. This is a virtual remote broadcast of an approved in-class course, 3 hours in duration, approved by GREC for CE. No prerequisites. I am the instructor, Dana Sparks. And again, you must be on time and present for all the remote virtual broadcast instruction hours in order to receive credit. Roll call and documentation of your license number will be conducted via the chat function at the beginning and end and after the break, as I've already mentioned. You may only receive credit for a specific course number once every 12 months. If you've already received credit for this course within the last 12 months, you are, of course, invited to attend, but will not receive additional credits. Prohibition of recruitment. No recruiting for employment opportunities for any real estate brokerage firm is allowed in the class or on school premises, which is loosely defined on Zoom, I guess. Report those promptly to either myself, the coordinator of the school is Heidi Kelly, or the Georgia Real Estate Commission. Heidi Kelly is also the person who will record the CE credits. We take 5 to 7 business days. Usually they're done within a couple of days, but we don't promise anything until after 7 business days. All right. And oops. I'm going to go back up here to the beginning. Oops, that should be 2021. Slideshow, please. All right, here we go, everybody. There we go. This is, give me 1 second. 1 second. Okay, we're back. 2021 RE Forms Contract Dissection, course number 72957. We will email the handouts to you. We are recording this class, so later on, if you want to jot down that web address, it's not password protected, or take a picture of it. A good hint when you're taking any Zoom class is have your cell phone handy, and you can always just take a picture of the slides instead of having to write fast and furiously. But anyway, at some point next week or in the next couple of weeks, the video will be up, should be up posted on that site as well as more copies of the handouts. All right. The contract forms. The RE forms in and of themselves were born and copyrighted in 2012. They did major revisions in August of 2014 and 15. At that point in time, they separated out the actual purchase and sale contract in and of itself from the standard terms. And as a broker, I really hate that they did that. They did that, I believe, because it did shorten the contract. And you'll see what I mean when I get into this. You guys type in the chat for me, just so I get a sense of who is on this class. What are the contract forms that you primarily use, GAR or RE? I'm just curious if you are here to learn more about the forms you are already using, or just want to know what these forms are all about, or if you're just here for the CE credit and it fit into your schedule. GAR. Okay, a lot of GAR. Okay, awesome. Perfect. Well, I've got to tell you guys, I admire y'all so much, because these forms are not going away anytime soon, if at all. And as I said, I'm not trying to toot my own horn for the school, but we are one of the few schools that do teach on these forms. And let me give you, just since most of you guys are using the GAR forms primarily, let me give you a brief history and staying out of the politics of everything, why these forms came about. So basically what happened was, when the market, I don't want to say tanked, I don't know if that's politically correct or not, but when the market had a drastic turn in 2008, there were a lot of real estate companies, a lot of mortgage companies, a lot of closing attorneys, a lot of people that went out of business just because of the market. If you were not around during that time, business just dried up, unless you were an investor or something along those lines. But the market really just was at the bottom of the cycle, unlike anything we had seen before, which we are in now, but at a different part of the cycle. Anyway, and so what happened was, with all of these companies going out of business, GAR, Georgia Association of Realtors, and National Association of Realtors, all of a sudden had a lot fewer people joining those organizations. And so they lost millions and millions and millions of dollars in dues money. Now, this is throughout the country, not just Georgia. And basically, if the qualifying broker of a company belongs to a local board of realtors, then every agent in that company must also belong to that same board of realtors. And many brokers belong to more than one, depending on if they've got branch offices, so forth and so on. So what happened was, a lot of companies went out of business. So there were a lot fewer people that belonged to a local board. And when you belong to a local board, part of your dues money goes to the state level, which is Georgia Association of Realtors, and part of your dues money goes to the national level, which is the National Association of Realtors. So a lot of these companies went out of business, and then a lot of new companies formed. There were a lot of REO companies that formed. A lot of owners of franchises, like the big national franchises, gave up their franchise and opened up their small local, just a small quote unquote mom and pop company. Well, a broker is not required to join a board of realtors. They just traditionally had in the past to support our industry and as a way of getting agents to mix and mingle from other brokerages. And back in the day, the boards were the only place you could go to get CE credit. You couldn't go to any one school or any one brokerage to get your CE credit. You really had to go through the board. So when all of these new companies popped up, they didn't belong to a board because they were really just watching their bottom dollar and just trying to stay afloat through the market cycle. And so since those brokers didn't belong to a board, none of the agents belonged to any of those boards. So again, no dues money going to GAR or NAR. So then what happened is NAR came to all of the brokers throughout the country of the traditional companies. They're like, hey, you guys, y'all need to recruit agents and get people to join the boards and pay their dues, so forth and so on. And what GAR did, GAR was really clever because we've been using the GAR contracts for years and years and years. I've been practicing for over 25 years, and the GAR forms were already well on their way since I've been practicing. So GAR, and that we were still using the GAR forms even after the market changed and people weren't joining GAR. So what happened was GAR was very, very clever. They're like, what do we have that people need? The contracts, and they're copyrighted. So they said, okay, here's what we're going to do. In the fall of 2011, GAR said, look, anybody can use our contracts, but you have to pay for the licensing to use our contracts this year. If you belong to a board, we're already getting your dues money, so there's no additional cost. So if you don't belong to a board, we're not getting any dues money from you. So you can still use our contracts, but you got to pay us for the year to use the contracts. So a bunch of the brokers that did not belong to any local board of realtors got together, and they're like, we need to create another contract that our agents can use, but not necessarily have to pay for. So that was the reason for the birth of the birth of the RE forms in 2012. So just to give you a brief history of how they came about. Not so much anymore, but there's still, you might hear some agents that have misheard their brokers by saying, well, my brokerage doesn't accept RE forms. And I say misheard their brokers because I seriously doubt a broker said we only accept GAR forms, because that would mean that those agents can't write contracts, can't help clients with new construction, because not all new construction is on a GAR form. Can't help buyers with a HUD house. HUD isn't a GAR form. An attorney written contract is not a GAR form. So that's why I euphemistically say misheard their broker. And license law says agents must present all offers regardless of the form it is on. Bottom line, it's up to your clients to decide which form they will accept or not accept. And you as an agent, it is your job to understand whatever contract form an offer or a counter offer is written on, so that your client can make the decision that's best to them with respect to whatever terms you are negotiating for that one transaction. So that's sort of a brief history of why they are even here. And they're such a big deal now because as a real estate agent, yes, all these other forms are in existence, but generally speaking, you as an agent, when you are initiating an offer or initiating a counter offer, you have more readily available access to either the GAR, Georgia Association of Realtors forms, or these RE forms via your MLS system or some other system. You typically have to get a HUD contract. You write it on their site, but they're the ones that generate the form. New construction, there are new construction forms in GAR and in the RE forms, but a lot of builders use the Atlanta Builders Association forms and so forth and so on. So just a little bit of background. So at first, it was just like the forms that we're used to, purchase and sale with all the legalese within one document. Then what happened again in 2015, the RE Forms Committee separated out the purchase and sale from the standard terms. And I believe, I don't know for sure, but I believe they did that to make the actual purchase and sale contract shorter. But as a broker, for customer service reasons and for helping you as an agent protect your license, I wish they had left it in, and I'll show you what I suggest you do. Anyway, they did minor revisions in 2019, and then they are continually, they did some additional revisions in 2020, and they are continually adding to the forms library. So the copyright date on the bottom of a lot of these forms will be different depending on when the form was created and if it has ever been modified. One of the big differences is the GAR forms require an agent, their license requires you as an agent to use the most current form. So now it'll say 2021. The RE forms, again, if it has not been modified since 2014 or 15, it's still going to have that date at the bottom, and it is perfectly okay to use that form. One other thing to be careful of, in the RE forms package, you'll see they have teeny tiny boxes to check. You really have to pay attention to it. I wish they'd make them a little bit bigger or a little bit bolder font, because even if you fill in the blank next to that contingency option, it's not part of the contract unless that box is checked. And again, this will make more sense to you in just a few minutes. So forms at a glance, generally speaking, and this document is available when you pull up your forms, but they are divided into categories, and you can search and index quickly. These are all the agency documents, all the disclosure documents, all the sales documents, financing contingency documents. So it's just easy to go to the index to see what you need, including all the miscellaneous documents and everything having to do with earnest money or security deposits. All right, so the contract, we're going to just start with the actual contract in and of itself, which is only 5 pages. This is Form RE100, and it is the basic terms of transfer of property between a buyer and a seller. It is 5 pages. The cool thing about the RE forms, different from the GAR forms, are the contingencies. The actual contract in and of itself for the RE forms includes 3 contingencies within the contract, and we'll cover those as we go through the class. The GAR form only has 1 contingency in the contract, the due diligence period. So you'll see again when we get a little bit closer, when we get to that part of the form. The standard terms, the contract in itself references the standard terms, and that's all the legalese. That's all the promises, consequences, and obligations of the parties when they sign the contract that they agree to do with respect to this contract. The standard terms is RE1, and it is 9 pages. So in essence, the RE forms, just the purchase and sale agreement, is 14 pages, because I really want you guys to include the standard terms as an exhibit when you help your clients go binding under the RE forms. It does state that the standard terms are incorporated by reference, and there is a public website where the public can go to pull these down. Again, point of practice, print and attach the contract as an exhibit. So here's what I mean. Let me see if this will be easier for you guys to see. Well, I'm going to do this way. I hope I don't make y'all dizzy, but okay. So this, y'all see that? There we go. This is the actual document itself. This is the contract for the purchase of real property. So this is page 1. And you'll see at the top here in bold, this is what I'm talking about. So now let me go over it back in the PowerPoint so you can see it a little bit closer. So this is what it says. This contract, meaning the purchase and sale contract, incorporates by reference those certain standard terms for the purchase and sale of Georgia real property published by Orthros Real Estate Enterprises. Now, just so you guys know how much of a big deal this is, I'm not 100% positive, but my understanding is Orthros LLC is a combination of FMLS and Georgia MLS. And y'all know they hate each other. They don't hate each other, but you know what I mean. So the fact that they formed an LLC together to create these RE forms, that shows you the importance in our area of the need placed on these forms without any charge to make available to agents who did not want to pay to use the GAR forms. But I digress. Anyway, so this contract incorporates standard terms which are available at this public website, www.reformsga.com. And in effect, as of the offer date, the standard terms become part of, by reference, into the contract. Each party, when they sign the contract, expressly agrees that he or she has read the standard terms and that it is his or her intent that the standard terms shall be incorporated into and are a part of the contract. So when your buyers and your sellers sign the offer and the contract, they're agreeing that everything in the standard terms is part of the contract. The issue is, did they go online and read this? Because this is what they're promising, and this is all the obligations and the consequences. I don't know. That's why, as a broker, I don't care who holds your license. Generally speaking, you guys really need to pull down the RE forms. Now, you guys don't have to go to the public website. They're available to you as an agent wherever it is that you access any of your forms, whether through whatever MLS system, FMLS, through Remind Docs, or through Transaction Desk, through Georgia MLS, or whatever system, wherever it is that you access your contracts, you have access. There is no charge to any agent in Georgia to access these RE forms, and the standard terms is available to you there to attach as an exhibit to the contract. Then it goes on and just describes what you would need for an enforceable contract for real property in Georgia anyway. You have the property address and the legal description, and together the seller is selling all of that with all permits, privileges, rights, members, appurtenances there too, and together with all improvements, fixtures, personal property, trees, timber, other crops, so forth and so on. Now, the purchase price in and of itself is spelled out in words and numbers. Remember when you used to write checks long ago? So that's how the RE forms has, when it talks about the purchase price and the closing costs, it has it spelled out in words and numbers. So it's not quite as much of an issue nowadays because everybody typically is using some sort of electronic device to complete their contracts. But some people are still handwriting them in, and people's handwriting can be sometimes a little bit hard to decipher. If, for example, the number 5, if you're writing the number 5, some people write all kinds of curly Q's and everything. So a 5 could easily look like an 8, or a 5 could look like a 2, or a 2 could look like a 5. A 7 and a 1, is that little line, is that a 7? Is it a 1? So in the RE forms, they have the words. For those of you who have been practicing for over 15, 20 years, you'll remember the GAR contracts also used to have all the price and the closing costs done this exact same way, where you spelled it out in words and you wrote it in numbers. So pop quiz. If there is a discrepancy between what is written out in the words and what is printed in numerals next to the $sign, which takes precedence, words or numbers? Type it in the chat. Which takes precedence, words or numbers? Words, words, words. Yes, you guys are correct. If there is a discrepancy, the words take precedence over the numerals that are spelled out on the contract. Now, earnest money. Again, the earnest money, you spell it out. Again, words and numbers, how much is the earnest money? And then who is it payable to whom? And that's where you put in the brokerage name. And these are teeny tiny check boxes, but you'll see, is it coming in by check, certified funds, money order, or cash? And then the payment of the earnest money, these first two options are the same. The first option under 3.1, this little teeny tiny check box, that is the buyer has remitted the earnest money to the escrow agent. For you GAR users, escrow agent is the same term as the holder in the GAR contracts. So the only way that you fill in the first checkbox under 3.1 is if you, in fact, have earnest money in hand when you are writing this offer. That means that the escrow agent already is in possession of the earnest money. The other way that that's happening now is we have a lot of buyers that are writing a contract, putting in earnest money, they're going binding, and then they're terminating for whatever reason. They get the earnest money released to them on a TNR, but the holder retains the earnest money while that buyer goes and finds another house. So that would be another situation where the earnest money is already in the possession of the escrow agent when you are writing the offer. The second option is the buyer has not remitted the earnest money to the escrow agent, but shall remit it, and remit is just a fancy word for send, the earnest money to the escrow agent within blank number of days from the acceptance date. Now, in the RE forms, they use the term acceptance to mean binding. So in other words, the buyer will send the earnest money to the escrow agent within X number of days from the binding agreement date. Now, in either case, once the holder or escrow agent is in possession of the funds, the escrow agent has 3 banking days to actually make the deposit of the buyer's earnest money. Now, this is example number 1. It says, escrow agent shall deposit into the trust account within 3 banking days from date of receipt of the deposit and a copy of the accepted contract. Now, look what this says. In the event the said payment is not timely remitted, in other words, the buyer never sends it, or if the bank doesn't honor it, then it's the same thing. The buyer has not remitted good funds. So if it bounces back from the bank, or the bank doesn't honor it if it's a check, or the buyer never sent it, the seller shall be promptly notified by the escrow agent, and the seller shall have the rights and remedies set out in this section. So let me show you what this actually looks like on the contract. Here's where we are in the contract. Hang on, let me let your screen catch up a little bit. There we go. Here's the section of earnest money. We're at the bottom of page 1. And here it is, 3 banking days. Seller shall have the rights and remedies set out in this section. So we go to page 2. Closing. You should be scratching your head. Don't you think a seller would want to know what their rights and remedies are if the buyer never sends in the earnest money? Yeah, exactly. I think a seller would want to. Where do you think the seller's rights and remedies are set out? They are set out in the standard terms. So nothing's an issue until it's an issue. So you're going to have a seller sign agree that you're going to receive this offer on the RE forms. Seller's going to sign it. You're going to be binding, and all of a sudden you're going to get notice that there's no earnest money. And the seller's going to say, well, what can I do? Can I terminate? What happens? What happens? Well, it's in the contract. Well, I don't see it. The next paragraph says closing. No, it's in the standard terms that you agreed that are part of this contract. And you said you went online to www.reformsga.com and read it. Did you read it? You should know. So do y'all see, are you beginning to see the issues why you need to attach the standard terms to this contract? And when we get to the standard terms, you'll see what their rights and remedies. So if we use the GAR forms, should be writing in the use of the RE forms. No, this has nothing to do with the GAR forms. In the GAR forms, it's a completely separate contract, and the rights and the remedies, if a buyer does not send in the earnest money, is all spelled out in the GAR form. It's spelled out in these forms too, just in the standard terms. All right. Again, this is just example number 1. I'm just trying to really impress upon you that you need to attach the standard terms and reference them as an exhibit in your contract. All right. Now, next thing is the closing. And then the closing is just like it is in anything. You put in the date of the closing attorney's office. In the RE forms, it does have a place, a location. That is for some of these closing attorneys that have multiple locations throughout town, you would put, that just helps to identify, are we closing at the Marietta office, at the Woodstock office, at the Powder Springs office, at the McDonough office, which office of this closing attorney if they have multiple offices. And Then now let's look at this. If the closing attorney is unavailable or unacceptable to the buyer's lender or title insurance company, then blank shall have the right to select a different closing attorney. So the buyer and the seller negotiate, buyer or seller has the right to select a different closing attorney. And then the same terms of possession in terms of, does the buyer get possession at closing or how many days and what date after closing? If the buyer is going to allow the seller to stay in the property after closing, you need to, this is what it says, you should execute and attach a separate occupancy agreement here too. You need to attach a temporary occupancy agreement to the contract if the buyer is not getting possession at closing. Now, just a couple of contract tips. You must put a firm closing date. So see here where it says closing shall take place, and this is the date. Do not put on or before, like you would not put on or before May 31st, 2021. They don't have that in there for a purpose. So y'all stop adding it in. For some reason, we're seeing a lot of contracts where the agents or the buyers and the sellers are putting in ambiguous dates, on or before May 31st. Well, that is not, that does not demonstrate a meeting of the minds. And by meeting of the minds, that's one of the elements for enforceability of a contract. And that means that the buyer and the seller have to agree on everything. So what can happen is if you say, and this has happened in the past, let's say you put closing to take place on or before May 31st, 2021. And then all of a sudden on May 20th, the loan is all done, the lender's ready to go, and the buyer's agent calls the closing attorney and says, hey, let's move it up. Let's close May 20th. We're good to go. Lender's good to go. The loan is geared for that day. So you contact the listing agent and you say, hey, guess what? We're closing May 20th instead of May 31st. And the seller says, well, I can't. I have nowhere to go until the 31st. I've got movers lined up. I've got a place to go. I don't have anywhere to go on the 20th. I only have somewhere to go after the 31st. I don't agree. And the buyer says, you already did agree because the 20th is before the 31st. So because of those issues, it does not demonstrate a meeting of the minds and it is ambiguous. So stop adding that in there, and you need to have a firm closing date. If you are going to have a date that changes from the contractual closing date, just change it via amendment. If you are going to, again, extend, you have to do an amendment. Now, one key thing, you agents who are used to the GAR forms, in these RE forms, there is no 8-day unilateral extension. There is no right to extend a contract by either party unilaterally. Any extension of a closing date must be done by a mutually agreed upon amendment. And again, as I said, if the buyer is going to allow the seller to stay in the property after the closing date, you need to use a temporary occupancy agreement, which in this contract package is RE 255, occupancy for seller after closing. In that form, let me see if I have a copy of that. Let me see if I've got that to show you guys. Oh, hang on one second. I just want to show you because this is a big difference. All right, I don't have it. I'll have to get it at the break. But in the temporary occupancy agreement of the RE forms, there is a fill in the blank for what they call a usage fee. In other words, the seller pays the buyer, who's the new owner, a fee for the privilege of staying in the buyer's home for a certain number of days. In the GAR Forms temporary occupancy agreement, that is not in there. The buyer just allows the seller to stay in their house, but there's no compensation written in that form for that. And then again, there's also a form for the occupancy for the buyer prior to closing. Don't do that. I strongly suggest you guys don't do that. All right, moving along to closing costs. In the RE forms, when a seller is making a contribution to the buyer's closing costs, you can write that either as a percentage of the purchase price or a flat fee dollar amount. In the GAR forms, there's only a place to fill in the blank for a flat fee dollar amount. I think this is really, really convenient for agents because you can just put in a percent that the seller is going to contribute X percent of the purchase price to the buyer for their closing costs. That way, if you negotiate, encounter, and change the price, you don't have to also change the closing cost contribution. It changes with respect to the purchase price because it is just a percentage. Now, here is where I was talking about the contingencies. In the RE Forms contract package, there are 3 contingencies built into the purchase and sale. When the buyers and sellers sign this, or even when a buyer is just making an offer on the RE Forms contract, the 3 contingencies are built into this and you don't need any additional exhibits. The first contingency is the buyer's general right to terminate, which is the exact same in the GAR forms, but the GAR forms calls it a due diligence period. But that's what a due diligence period is the buyer's right to terminate the contract for any or no reason. In the RE forms, you also have built in an appraisal contingency and a financing contingency. So you don't need any additional exhibits for a buyer to be protected by making their contract contingent upon subject to an appraisal or they're getting financing. In the GAR forms, you would need a separate exhibit if your buyer is making their contract contingent or subject to appraisal and financing. But let's look at what these say. So, buyer's general right to terminate. This contingency shall expire at 11:59 p.m. on the day that is blank days after the acceptance date. Again, acceptance date is binding agreement date. In consideration of the seller granting this, the buyer's general right to terminate, buyer has paid seller $10 non-refundable option money, receipt and sufficiency of which is hereby acknowledged. That $10 never changes hands. Now let's look at the next one, appraisal contingency. This contingency expires at 11:59 on the day that is blank days after the acceptance date. Well, what happens if it doesn't appraise for sale price? What are the options? Can anybody terminate? Do you have to give the seller the right to sell it for a lower price? What happens? Guess where all of that is fully explained? Yep, you guessed it, the standard terms. No, I'm not going over the GAR forms too. This is just an RE forms contracts class. The GAR forms is a whole separate class. I am pointing out some of the comparisons, just some of the bigger comparisons, because I have so many people on here that are familiar with the GAR, but this is not a comparison and contrast class. This is just going over the RE forms. But yes, the standard terms. So what happens if it doesn't appraise? All of those obligations and what has to happen and who has termination rights, if any, and time frames and notices, all of that is spelled out in the standard terms. And then the next one, the financing contingency expires at 11:59 blank days after the acceptance date. If the buyer and seller agree to financing. So this is all you need if the buyer's getting a conventional loan. If the buyer is getting an FHA or a VA loan, you do have to attach an exhibit for those. And the easiest way to remember that is the FHA and the VA are government agencies. And when you think of government, what do you think of? Wait, that's a really loaded question right now. Don't answer that. Please, yes, red tape. There you go. I like that answer. Red tape. You want to think of extra paperwork, extra. So when a buyer is getting a government insured loan, FHA, VA, or USDA, you are going to need an extra document. So that's the easiest way to remember that. But if they're just getting a conventional loan, this is all you need. All right. Now, again, this is a little bit about what I was talking about. Let's say under 6.1, buyer's general right to terminate, and you put in 5 days, 7 days, 10 days, whatever time frame the buyer is negotiating for a due diligence period. Even if you fill in the blank on any of these, if you fill in the number of days, you must check this little box. If you do not check the box, even if you fill in the blank, it is not part of the contract. So on one hand, that means if your buyer is paying cash for the house, you simply do not check financing or appraisal contingency, and you know it's a cash contract. On the other hand, if your buyer is getting a loan and you don't check those boxes, it is a cash contract. Even if you fill in 10 days or whatever time frame up here under the buyer's right to terminate, if you don't check the box, you are not giving them a due diligence period. So you've got to check the boxes, even if you fill in the number of days. All right. Now, just a quick note. In the RE Forms contract package, there is a separate exhibit called the Appraisal Contingency Exhibit. There is an additional exhibit called the Financing Contingency Exhibit. However, if the buyer and the seller go binding on the RE forms, you do not need to attach those exhibits. All of that information is spelled out in a combination of the contract and the standard terms. The only reason those two forms are in existence is if you are representing a buyer and you write an offer on an RE forms and the listing agent is not familiar with the RE forms and is more familiar with the GAR forms, and the seller chooses to make a counter offer by rewriting everything on a GAR purchase and sale agreement, they may not realize that they would also need a loan contingency exhibit in that counter offer. So let's say you're the buyer, you write the offer on the RE forms and you send it to the seller. The seller makes a counter offer to you by rewriting all of the terms on a GAR purchase and sale agreement. Well, in their counter offer back, they did not include the loan contingency exhibit. At that point, if your buyer accepts the rest of the terms of the GAR, you still are going to have to make a counter offer by pulling out the appraisal contingency exhibit and the financing contingency exhibit and completing those and sending them back. So that's the only reason those two exhibits are in existence, is if you're doing the switcheroo between the GAR and the RE. And this is what they look like. But all of the verbiage in these two exhibits is already contained in the RE Forms contract, RE100, and the standard terms RE1. So you do not need those if the parties go binding under this form. Now, continuing on, let me show you again a little bit what we're talking about. I think it's easier to see it. So we are on page 2 of the actual contract. Here's the paragraph about closing. Here's the paragraph about closing costs. And then here's where we're talking about the contingencies. And it has, again, the buyer's right to terminate, appraisal contingency, and financing contingency. Now, under the financing contingency, if the buyer, if they're getting a first mortgage through a lender, just like any, a traditional loan, you have to fill this out. You must fill out, just like you have to fill out the terms of their financing, percent of how much they're putting down, the interest rate, is it an adjustable rate, a fixed rate, so forth and so on. And this is under the financing contingency. So that's within this same paragraph. So this is just a little bit closer view. And again, you mark the check boxes that they're getting a first mortgage, and that's the percent of the purchase price. That's the number of years, the interest rate, fixed rate, so forth and so on. All right. Again, you still have to fill that part out. But if your buyer is getting an FHA or a VA loan, you have to additionally fill out, as we said, red tape, an FHA loan exhibit or a VA loan exhibit. And I believe I cover those a little more in depth after we go through the purchase and sale. Now, the next paragraph in the contract talks about inspection of the property. And it states the buyer has the right and obligation with reasonable notice to the seller to inspect the property and the improvements, checking out all kinds of things. For example, AC unit, electrical, fireplace, lead-based paint, mold, radon, roof, termites, so forth and so on. Now, this says you check one, either the buyer and the buyer's representatives have the right to go into the property with notice to the seller from 9 a.m. to 7 p.m. and you fill in whatever time frames. 9 a.m. to 7 p.m. is great when we are under standard time. However, now that we are in daylight savings time, you probably want to extend that because it doesn't get dark until 8:30, and it's going to be close to 9 o'clock. So you probably are going to want to change that because we have more hours of daylight right now. Additionally, the next section says, in order to facilitate the inspection, check this out, buyer or seller shall make all required utilities operational and available. So in this, you check which party is responsible for the utilities. And then the burden is on the buyer to check out and make sure about the neighborhood. Is it a meth lab? Are there sex offenders? And it does have the links for them to go to check those out. Buyer, the next section is on agency. Let me look at this question. Can you confirm that in GAR, we would check the box as it's not covered in the contract? We would also check FHA or other. I'm not going to talk about the GAR contract because this class is on the RE forms. I'll just say in the GAR contract, the FHA loan contingency exhibit has all that information on the separate exhibit in and of itself. So I hope that's what you're asking, Gary. All right. The next section in the contract talks about brokerage. And this is just, you should be familiar with this with any contract, that you must identify a material relationship. A material relationship is a relationship between you as the agent and your broker and one of the public parties, either the buyer or the seller. Whether that be a family member, a business associate, a past client. If you have a relationship, a previous relationship, then you need to disclose that. And then it talks about the buyer's broker, whether the buyer is working with the public, whether the broker is working with the buyer as a customer or client, you still disclose, are they a client? Are they a customer? Is the broker acting as a dual agent, or is it a designated agency situation? The same thing for the seller. And then you go on below. If it is a designated agency situation, you indicate which agent is working with the buyer and which agent is working with the seller. Now, you don't need to fill that out if there's two separate brokerages involved. So just quickly, a client relationship means that your public buyer or your public seller has signed a brokerage agreement with your broker and is choosing to work with you as a client. So for a seller, that would be a listing agreement. For a buyer, that would be a buyer brokerage agreement. If they are a customer, there is nothing that requires by law any documentation for them to sign, but your broker may have a policy. And even if your broker does not have a policy, then I strongly suggest, because you are an independent contractor, that you get your public person to sign the customer disclosure so they understand the legal relationship between them as a public person and you and your broker. And the RE forms does have a customer acknowledgement for a buyer and an authorization to show property not listed for a seller. Those documents describe the customer relationship between the public and your broker. Dual agency means there's one broker, one agent, and that agent has a listing agreement signed with the seller, making them a client, and a buyer brokerage agreement signed with the buyer, making the buyer a client. Designated agency is one broker, two agents. One agent, it has a buyer brokerage agreement signed with the buyer. The other agent has a listing agreement signed with the seller. And the easy way to remember that is it's still within the same brokerage, and the broker has designated agent A to work with the seller and designated agent B to work with the buyer. If that's the situation, that's the only time that you're going to fill in this 8.4, and you spell out, even though it's on the signature page, you write out which agent is working with the buyer and which agent is working with the seller as a client. All right. Wire fraud disclaimer. Wire fraud, you guys, is just a horrible, horrible issue in our business right now. It impacts real estate agents. It impacts lenders. It impacts closing attorneys. Point of practice, never, ever, 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 ever email. It's just the emails that are getting hacked. Never email wire instructions to your buyer or your seller, whether that be for earnest money, whether that be for cash to close, whether that be for a payoff, whether that be for proceeds. Don't email wire instructions from your own broker, and do not be the messenger of wire instructions from the closing attorney to your client. The emails are getting hacked, and the courts have demonstrated a couple of years ago that you will have financial liability if your email gets hacked, even unknowingly, and a party wires money to a fraudulent account. There was a court case a couple of years ago, and the agent was found liable for 80% of the amount that was stolen from the buyer. So if you have to get wire instructions from your broker to your client, send them via US mail. If the closing attorney has to get wire instructions to your client, let that be handled between the closing attorney and the client. I do caution you guys have got to make your public people, even your sellers too. It obviously happens more with buyers wiring earnest money and cash to close, but for sellers too, if they're getting their proceeds wired to them rather than receiving a check, or if a closing attorney is wiring a payoff or something like that, you have got to instruct your public people to verify the wire instructions themselves from a phone number, not that comes on the email with the wire instructions. So in other words, if you have a closing attorney and they send your client wire instructions, your buyer, wire instructions, your buyer should then not go with that email or information they received. They need to call you and get the phone number of the closing attorney, or they need to go to Google and look it up separately to confirm with a third-party phone number and just confirm the wire instructions. It's just a horrible issue right now. All right. And then the exhibits, you mark which exhibits are included. Again, I strongly encourage you guys to do this. I want you guys to put a big old, let me make this red. Put a big old X right there. And then I want you to write standard terms. In other words, I want you to, I don't know how to, oh well. I want you to pull down the standard terms from RDocs Plus and FMLS and Transaction Desk and Georgia MLS, attach them to the contract and reference them as an exhibit. And then here is a place for special stipulations. And I caution you guys against writing any special stipulations. Okay, let me look at another question. You leave the seller's broker section blank for them to fill out, or call and ask them to fill it out ahead of the buyer. Well, you'll get, if you're finding the property on one of the MLS services, you're going to have all that information. So I strongly suggest you fill out as much of the contract as possible, including your co-op agent's brokerage information that you have readily available access to if you found the property via an MLS service. You guys, think customer service. How many times, what's the likelihood that you're going to interact with your public person, the same public person with real estate again? Like once every what, 5-7 years or so? What's the likelihood that you might do business with your co-op agent again? Hopefully sooner than 5 or 7 years. I take the stance that all real estate agents have 2 sets of clients in any one contract. They have their public people, whether that be the public buyer or the public seller, and you also have your co-op agent. If you go into any and all contract with the perception that your co-op agent is also your client, I think it will make for a smoother transaction, number one. Number two, I think it just demonstrates excellent professionalism and customer service. Number three, I think it's a good example of the golden rule, do unto others. Wouldn't that be nice if you received an offer and your stuff was all filled in? The easier, the better. And it also communicates that you guys as the professional agents are going to work together to help your buyers and your sellers convey property. So I always suggest that you do whatever you can with the information that you have. I will also say, generally speaking, a contract is binding between a public buyer and a public seller, even if you guys as agents don't sign the contracts. Y'all are not the essential parties to the contracts. However, we did have a situation actually 2 years ago where the agent never signed the contract. It was completely enforceable between the buyer and the seller. The problem was the lender had an issue with it because one of the lender's underwriting terms, they did not service their own loans. They sold their loans on the open market, and that loan could not be sold without the real estate brokerage filled out and signed. So it was enforceable between the parties, but the lender was not able to sell the loan without that. So the buyer actually ended up terminating because it couldn't get the listing agent to sign it. But it has nothing to do with enforceability. That's just an interesting thing. All right. Oops, now I got to get rid of this. Now, in the priority of things in a contract, and this is any contract, you have the written purchase and sale agreement. Then if you attach an exhibit, anything in the exhibit will supersede what's already in the purchase and sale agreement. Then if you write a special stipulation will supersede what's in the exhibit, which supersedes what's in the purchase and sale agreement. Therefore, do not use an exhibit for an issue already addressed in the contract, and do not write a special stipulation for an issue already addressed in the contract or an exhibit. In other words, if you have, and this is true of any contract, this is just general contracts 101. If you have a purchase and sale agreement and an exhibit or an exhibit, like for example, let's say in the RE forms. Let me show you guys the forms. Okay, hang on. All right, here we go. There we go. We already said in the form in and of itself, there is an appraisal contingency, so many days from binding agreement date. And you'll see when we get to the standard terms, I'm just going to skip here really quickly. I have to make this point. Here is all the information about the appraisal contingency. Make this big for you. So this is what it says, what happens if the property does not appraise. And I'm going to cover that a little more in depth. My issue is when you guys write a special stipulation that says property must appraise for sale price, your special stipulation is going to supersede or take precedence over any exhibit, which takes precedence over what's already in the contract. The contract has the consequences, timeframes, notices, what has to happen, termination rights if the property does not appraise. If you add a special stipulation that says property must appraise for sale price, well, what happens if it doesn't? Well, I don't know. Can the buyer terminate? No, not necessarily. You didn't write in termination rights. Does the seller have to sell it at that price? Well, I don't know. You didn't write that in. So you guys, stop writing special stipulations for something that is already addressed in the contract or in an exhibit. If you must write a special stipulation, stop writing them on your own. There are a gazillion special stipulations this is the special stipulations library of the RE forms. Here's the 1031 tax exchange, agent acting as principal, appraisal to establish purchase price. That's happening for like some land where there's absolutely no comps. And it's just hard to come up with a price. Appraisal review. Look at that. That one's interesting. If buyer's lender requires appraisal review, timeframes. Assignment, if you're going to assign the contract to, if the buyer's going to assign the contract, if it's an investor and assign it to somebody. Contingent upon all sorts of things. Contingent upon a dock permit. Disclosure statement is missing. Earnest money. Interest rate fluctuations. Lease purchase. Manufactured mobile home. Rent prorations. Seller divorce proceedings. Seller to have costs. I know I'm making y'all dizzy by going through these quickly. Home warranty. Repairs after loan approval. Remove fixtures prior to closing. Association, community, or zoning compliance. Flood zone. All this kind of stuff. All of these special stipulations, termite letter, termite bond, are already written out for you in the library, and it has what happens, the consequences, who is responsible for what. If you do not see something appropriate, please get with an attorney or your broker, but stop writing them yourselves. All right. And then we have the time limit of the offer. And then we have the, again, it says accepted, but this refers to the binding agreement date. The time limit means the offer is open for acceptance with no changes. So if the buyer writes an offer and let's say they put a time limit on it of, let's see, what's today? Today is April 14th. Let's say the buyer writes an offer and they put a time limit on it of 5 p.m. April 14th. And let's say the seller is going to make a counter offer and counter the price and the closing costs. I'm telling you guys right now, this is a trick question for some of you. May the seller make a counter offer after 5 p.m. Buyer writes an offer. The time limit is today at 5 p.m. Seller is making a counter offer. They're countering the price and the closing costs. May they make a counter offer after the time limit, after 5 p.m. today? Some yeses, some no's. I don't know why this is so confusing, even for my most, maybe. That's a way to hedge your bet, right? Okay, this gets confusing even for the most experienced agents, and I'm not quite sure why, but let me go through it to try to help everybody get on the same page. The time limit says that this offer with these terms is open for acceptance until 5 p.m. today. If I'm going to make a change, if the seller is going to make a counter offer and change the sale price and the closing costs, are they accepting these terms? No. So the time limit is of no consequence if a party's going to make a counter offer. A seller can make a counter offer before 5 o'clock. A seller can make a counter offer tonight at 10 o'clock. A seller can make a counter offer tomorrow at 10 o'clock. Guess what, you guys? A seller can make a counter offer next week. A counter offer is a non-acceptance of these terms with no change. A time limit means no changes whatsoever. The seller, in order to have a binding contract, the seller would have to sign before 5 o'clock tonight. If they're making a change, the time limit's off the table. It doesn't matter because they're not accepting the terms. They're not accepting the offer. For example, Macy's is having a sale. They've got a gorgeous purse. They've got a $600 purse on sale for $50. The sale ends tonight at 6 o'clock. I am busy all day today. I cannot get to Macy's until tomorrow. If I go to Macy's tomorrow and pull that purse off of the shelf and bring it to the cashier and hand them my $50 for that purse, are they going to take it? No, that offer was only open for acceptance. They only would have accepted my $50 for that purse until 5 o'clock tonight. If I go tomorrow, it's off the table. It's no longer open for acceptance. So now I can still get that purse, but now I have to pay them the $600, if that makes sense. So a counter offer, if there's going to be a counter offer made, the time limit has absolutely nothing to do with it. A party can make a counter offer at any time, because in essence, a counter offer is a new offer. It's just initiated, in my example, by a seller to a buyer. So I hope that makes sense. And then this next section, it says accepted. It really means binding. I really wish they would have used the word binding. But basically, that's when a buyer and a seller agree on terms and all parties have noticed that there is an agreement on terms. All right. Now, the next thing right before the signature is it has a little checkbox and it's all in bold font and it has a place for buyer and seller initials. And it says, by initialing here, the parties acknowledge the receipt of a printed copy of the standard terms. Failure to initial means that they have gone online and they agreed that the public website, www.gaformsga.com, that they've looked at that and they agree to that. Again, you guys protect yourselves, protect your license, exhibit good customer service by going ahead and attaching those documents and referencing it as an exhibit, the standard terms. And then just like normal, there's a place for buyer's name, seller's name, signatures, contact information, brokerage names, broker codes, your license number, and your firm's license number. All right. Now, before we get to the standard terms, let's see, what time is it? It is 10:45. We go till 9:30, 10:30. We go till 12:30. Okay, let's go through the standard terms just a little bit and then we'll take a break. Sound good? All right. So let me show you where we are contract-wise. So here's again the purchase and sale agreement that we've just gone over. And again, it in and of itself is only 5 pages. There's more information in here. I'm just not covering it because I just want to hit the highlights. There is a disclaimer about technology. There is a section on default. Actually, let's look at the default. Am I? No, I'm in the standard terms. Hang on, I'm in the wrong place. Okay, this is the actual purchase and sale agreement. So here's where we are. Here's the section that they say about the standard terms. Here's where they sign. And one other thing I didn't point out is there is a place in the RE forms for your buyers and sellers to initial at the bottom of every page. And that's it for the actual contract in and of itself. Then the next form, these are the standard terms. So again, this is a completely separate document. And it says these standard terms for contract for the purchase and sale of residential real property as published by Orthros Real Estate Enterprises, LLC, are to be used in conjunction with an executed contract for the purchase and sale of real property as published by Orthros and are not intended, absent of an executed contract, to be binding on any party unless incorporated. In other words, this is not a standalone document. As a matter of fact, there is no place on this document for the parties to even initial or sign, because it is incorporated into the actual contract. But this is where everybody knows what's going on. It's all the legalese, it's all the promises, it's all the obligations, and it is the consequences of meeting those obligations or not meeting those obligations. So the first thing is that the seller, what they are conveying is good and marketable title, and they are conveying the warranty deed that is a limited warranty deed. And limited just means the seller warrants the deed to the property only for the time of their ownership. Same type of deed is conveyed in the GAR contract, limited warranty deed. And free and clear of all mortgages, liens. The only thing the property is subject to are taxes not yet due. And again, that's handled at the closing table. Any encumbrances, zoning, so forth and so on. Now, what does good and marketable mean? Well, it is defined here at the bottom of this paragraph. Good and marketable title, as used in the contract, shall mean title which a title insurance company will insure at its regular rates, subject only to standard exceptions. So this does not mean insurable. It has to do with the premium price for that title policy. And then it talks about purchase price, and then we talk about earnest money. So these standard terms, you guys, this is a general document that is used not only for buyers and sellers going binding for the purchase of a resale property, but these are also the standard terms used if the parties use the RE form contract for new construction. So you're going to see a lot of information in these standard terms that have to do with new construction that is not applicable if you are using the contract for resale property. But since it is a multi-purpose form, you're going to see that information spelled out here, but it has nothing to do with that. And you'll see what I mean in just a minute. So then it talks about that the escrow agent has to put the earnest money in a trust account, so forth and so on. Now, remember back here in the contract, let me go back here. The very first, page 3, the bottom of page 3. Remember we talked about, it says the buyer has to remit the earnest money within X number of days of binding agreement date. The holder has 3 banking days to deposit. If the buyer never sends it or it's not honored by the bank, the holder sends notice and the seller shall have the rights and remedies set out in this section. Remember, and then it went to closing. Well, in the standard terms, now we have the seller's rights and remedies if the earnest money was never sent or not honored by the bank. And that's what it has in paragraph 3.3, buyer's failure to remit the earnest money, regardless of if it was sent before the binding date or whatever date agreed to. If it is not honored by the bank or it was not received, the escrow agent shall promptly notify the buyer and the seller, hey, look, we don't have the money. The buyer said they were going to send it. We said we deposit it. We do not have it in our banking account. At that point, the earnest money shall be paid by certified check within 3 days of the date of notice. So the escrow agent says, look, everybody, we don't have the money. The buyer has now defaulted on the contract. However, so when you give notice of default, then the party that has defaulted has a time frame within which to cure. With respect to this, the buyer now has 3 calendar days from the date of notice to make good on the money. If the buyer does not remit those funds or make good on the money within 3 days of that date, then the seller has the following rights. The seller may unilaterally terminate the contract within 7 days of receipt of the escrow agent that the buyer never cured. And then they just go on with life and go on and accept another contract. If the seller holds the earnest money, that really has to do with new construction. A lot of times a new construction seller will hold the earnest money. Or in a resale, the seller can say, look, okay, I agree. There's no earnest money in the deal. You did not make good on the earnest money, but I'm not going to terminate the contract. We're going to go through with the contract and go to closing. So earnest money is not required for an enforceable contract. So it is the seller's option. Now, if the seller wants to terminate, their time frame to do so is limited. No, the earnest money is never sent, or it bounces from the bank. Buyer has 3 calendar days to make good on that money. If they don't make good on that money, the seller then has 7 days thereafter to decide, am I going to terminate or not? After that time frame, the seller can no longer terminate and not be in default of the contract, and they would go to closing. But don't you think a seller would want to know that? Absolutely. If I'm a seller, I would want to know that. All right. Now, moving along, what happens once the escrow agent has the earnest money? How do you get it back to the parties? Well, this is normal. You guys are all familiar with this. If the escrow agent is holding the earnest money and the buyer never goes under contract with anybody and they stop their home search, then the holder can just write them a check back and refund their earnest money. Or if you go to closing, which is the best thing to do, then the earnest money gets credited to the buyer at closing. Now, the other way is if the holder gets an order from the court, if it somehow ends up in the court system and a judge comes back and says, okay, holder, you need to disperse the earnest money in this method, then of course the holder must comply with a court order or an arbitrator. Now, what happens if a contract terminates and, the other thing it says up here, I don't have it underlined, but the other thing it says, here it is, little number 4, right here at the very bottom. The earnest money may be dispersed by the escrow agent pursuant to a separate, let me write this. Pursuant to a separate written agreement signed by the parties agreeing to the terms of the disbursement. We lovingly refer to that as the T&R. The T is the termination and the R is the release of the earnest money. So if a buyer and a seller are under contract and they don't go to closing and it gets terminated, there has to be a separate agreement where the buyer and the seller agree who gets the earnest money. If the holder gets that, then the holder just disperses the earnest money based on that agreement. If a contract terminates and the buyer and the seller do not agree on who gets the earnest money, then what happens is what we call the 10-day letter. And the reason it's called the 10-day letter is because of this. And what this says is, if buyer and seller don't agree in writing as to how the holder is to disperse the earnest money, then the holder has the obligation to go through the contract, figure out what did the parties agree to, why didn't it close, the party that failed to close, did they send a termination? Did they just not show up to closing? What happened? Did they terminate by an agreed upon contingency prior to the expiration of that contingency? So forth and so on. In other words, who is entitled to the earnest money based on what they had agreed to in the contract. So then the holder goes through the contract, makes that interpretation, writes a letter saying, this is my intent. I intend to disperse the earnest money of this amount of money to whichever party for this reason. Now, I can't just disperse it immediately. I have to wait 10 days for the party not getting the earnest money to make an objection. Let me tell you, they all make an objection. The issue is that objection based on something in the contract, or are they just upset? So that's why it's called the 10-day letter, because there's a 10-day time frame that the parties can make an objection. And sometimes it could be, no, this contingency ended via this amendment. And the holder's like, oh my gosh, I never got a copy of that amendment. Or no, they did everything they had to do. You're just upset and they're entitled to the earnest money back. Whatever it is, the holder does that interpretation, sends out a notice, And if they do change their mind, they send out a new 10-day notice. If not, then they disperse the earnest money on at least day 11 or thereafter. The other thing that the holder can do is it's too legally complicated or it's way too much money and I am not an attorney, I am a broker, I am not going to be responsible for this. I'm going to interplead it into a court, meaning I hire an attorney, that attorney files a motion and we say, okay, we need a judge to decide who gets the earnest money back based on this termination. Now, can you do anything in the court system or anything with an attorney for free? That is a rhetorical question. The answer is no. So there are court costs and legal fees involved with a holder having to interplead the money into a court to let a judge decide. So two things you guys need to know. Number one, guess where I as the holder get to take my fees out of? I get to take them out of the earnest money. Number two, it is an actual lawsuit. So if it does go to court, the buyer and the seller are going to have to appear in court to defend their position, why they get the earnest money back. They can either defend themselves or they have to hire an attorney. Number three, the loser in court may have to pay the winner's legal fees. So it is a huge deal if the earnest money is going to be interpled into a court. So if the court costs are anywhere from $750 up past $1,500. So if your earnest money is less than $5,000, there's really nothing left after it goes to court. So one thing that the parties can do is they can negotiate between themselves and decide to split it 50-50, 60-40, 70-30, 80-20, whatever. And again, if they give written notice to the holder before the interpleader action gets initiated, then the holder can just disperse based on what they agree. Additionally, it does say that based on the escrow agent or holder's decision on the 10-day letter or decision to interplead the funds, they are not liable for any loss, cost, damage, which may occur as a result, and the buyer and seller agree to release the broker from any liability. This next section, again, remember I said this is a multi-use form for builders. And then closing, it just talks about closing, it talks about new construction. The title defects, the seller is responsible for clearing any and all title defects. Parties agree to prorate. All of this stuff is consistent with the contracts you're used to looking at. Now, let's look at the closing costs. When the seller has agreed either a percent of the sale price or a flat fee amount to contribute to the buyer's closing costs, what can the buyer use them for? Well, I'm sorry, I'm taking a sip of water. It says that the closing costs, first of all, if the lender uses them based on any lender's underwriting criteria, then it goes on to say the additional closing costs may be used for any purpose whatsoever to offset the closing costs incurred by the buyer, such as title insurance, financing, HOA dues, regardless of what the cost is required by law, the lender, or merely at the discretion of the buyer to close the transaction. What does all of that mean? Well, what it means is that when a seller agrees to make a contribution to the buyer's closing costs, after those fees are used towards prepaids, escrows, so forth and so on, if there's money left over, then it can be applied as a buyer credit towards anything. It can go to pay their hazard insurance. It can go to pay their HOA dues. The buyer gets to use the entire amount that the seller is contributing for anything, even and above closing costs, if there's money left over. That's what that means. All right, let's go over the contingencies and then we'll take a break. All right, so again, remember in the contract in and of itself, we had the 3 built-in contingencies: buyer's general right to terminate, appraisal contingency, and the financing contingency. Well, let's see what is involved in all of that. All of that is defined over here in the standard terms. Buyer's right to terminate. Again, we're used to thinking of that in the language that we use among ourselves as professionals as the due diligence period. Now, look, this is why I told you guys to check those boxes. Don't believe me, but your contracts are nothing more than a set of instructions. Well, why did I say that? Because it's in the instructions. This contingency shall only be granted by the seller if the appropriate box related thereto is checked within the body of the contract. That's why I said it doesn't matter if you fill in the blank here. You've got to check this box. If you do not check this box, then even if you fill in a number of days, it is not part of the contract. The reason I say that is because it says it right here. It's only part of the contract if that little teeny tiny box is checked. Very important to check the boxes. All right, let me erase my little X, marks the spot. All right. Now, what does this mean? And again, you guys, basically, it's exactly the same as a due diligence period. The seller gives the buyer the right to terminate the contract for any or no reason, as long as they send notice of termination prior to the end of that time frame. Now, so there's all kinds of things a buyer can do to decide, am I going to go through with this contract or am I going to terminate it? A buyer can have an independent home inspector check out the property. A buyer can check out the roof. A buyer can check out the foundation. A buyer can check it out for termites. A buyer can make sure their financing is going through. A buyer can make sure that the property is in the school district that they think it's in. A buyer can check their commute to work. A buyer can see what is going on in the neighborhood behind. A buyer can check the zoning, the DOT plans, and see if they're planning on building a road. A buyer can make sure that their significant other likes the house. A buyer can make sure their parents like the house. There's all kinds of things that a buyer is going to do. A buyer can have the property surveyed. All kinds of things a buyer can do to help the buyer with their decision. Am I going to go through with the contract or am I going to terminate the contract? Again, if a buyer can also ask the seller, look, I'm thinking about, I want to go through with the contract. I'm wondering if you will address these concerns. I'm wondering if you'll put a new roof on it. I'm wondering if you will replace and repaint the rotten wood around the windows. I'm wondering if you will repair the GFCI IC outlets, you know what I'm talking about, with reverse polarity. I'm wondering if you will clean the carpets. So a buyer can ask the seller to do that. The seller can say, yeah, I'll do that. A seller can say, I'll do this, but I won't do that. Or the seller can say, nope, I'm not doing any of it. If a buyer chooses to go through with the contract and the seller they don't come to terms on that amendment during that time frame, the buyer is accepting the property as is. All right, now, moving on to the appraisal contingency. Again, this contingency shall only be granted if the little box, this little teeny tiny box, you need to check it. If that's not checked, there is no appraisal contingency. Now, what happens if it doesn't appraise? So basically, this is what it says. It says, subject to any expiration date, the seller gives the buyer the conditional right to terminate the contract if the buyer does not receive an appraisal of the property by a licensed Georgia appraiser showing that the value of the property to be equal to, or greater than the purchase price. In other words, if you get a low appraisal, then the buyer, at the buyer's sole discretion, shall have the right to request a reduction in the sale price by the seller. And what they have to do is that they have to, okay, so let me get rid of all this. Okay, where's my eraser? There we go. Basically, what all of this says is, if the appraisal comes in low, the buyer has the right to ask the seller to sell it for the appraisal price. They have to send them a copy of the appraisal, and they have to send the amendment asking the seller to do so before the end of this time frame. All right. Now, they don't have to. If the appraisal comes in low, the buyer also has two other things they can do. Number one, they can terminate the contract. Again, they must terminate before the end of this appraisal contingency time frame. Or the buyer can choose to pay cash for the difference and go on and buy the house. But the seller does have the right, and all of this information spells out more time frames if the buyer does ask the seller to sell it for the appraisal price. Now, moving on to the financing contingency. Again, it's only subject to financing if you check this little box, regardless of any of this information filled in. So now what does it say? Well, this means that the buyer must convince a lender to lend them the money. And the buyer has so many days from binding agreement date to do that. If a buyer cannot convince a lender to lend them the money, then they have to terminate the contract before the end of that time frame, and they have to prove it. They have to get a loan denial letter from a lender, but the loan denial letter can't just be general. It's very specific. And that's what this says in these paragraphs here. It says that the loan denial letter, first of all, must be the loan that's being denied, must be this loan that you described here in the purchase and sale agreement. And the loan denial letter cannot be based on, I'm here under paragraph 6.3.1.2. Buyer's lack of sufficient funds to pay for the down payment or closing costs. If the loan application was not timely submitted, if the buyer failed to sell or lease their current home and you didn't have a contingency exhibit as part of the contract, or look at this last one, the buyer's conduct after the acceptance date but prior to the expiration. What that means is if you have a buyer and their credit and everything looks good right now, and then before they go to closing, they go out and buy a car, or they go out and buy a whole house full of furniture, same as cash, and they wreck their credit, that is their conduct after acceptance date but prior to closing. If their credit score changes drastically because of that, and the lender will no longer lend them the loan, not only are they not going to get the loan and terminate on the purchase and sale agreement, they are going to lose their earnest money because that does not meet the terms of the financing contingency protection of their earnest money. Now, one more thing, and then we're going to take a break. This paragraph right here, 6.3.2. So let's talk for a second. Remember I said in the RE forms contract, there is no 8-day unilateral right to extend the contract. Any extension of the contract must be done by an amendment signed by the buyer and the seller. Well, we have new laws in place called the TRID laws that were activated for this specific reason in October of 2015. And basically the part of the TRID laws, TRID stands for Truth in Lending, RESPA, Integrated Disclosure. And part of that law is, it's a federal regulation that a lender and a closing attorney are prohibited by this federal regulation from closing a contract for a buyer if the lender has not sent out certain disclosures, financial disclosures to the buyer. In other words, certain finances, certain fees that the lender may not change. Now, it's not a final cash to close, because if the date of the closing changes, then some of those prorations are going to change. but it is in essence lender's fees that cannot change. The lender must send out those fees that cannot change to a buyer 3 days prior to closing, or they are federally prohibited from closing. Well, so what happens if we can't change the closing date and it's a federal prohibition to close the contract? Well, and we call those the TRID disclosures. Well, the RE forms contract has taken account of that. And basically that's what this paragraph 6.3.2 is. It says, if the underwriting guidelines of Fannie Mae, Freddie Mac, FHA, USDA, or VA mandate compliance with any underwriting criteria contrary to the provisions of the contract, those provisions shall prevail and be binding. However, if any of those guidelines result in an increase in cost or expense to the seller or affect the date of closing, so a lender not sending out those TRID disclosures in time might affect the date of closing, then the seller, at the seller's sole discretion, shall have the right to unilaterally terminate the contract within 3 days of the seller's receipt of notice of the applicability of the guidelines. If the seller does so, then they send notice of termination. If the seller does not terminate the contract, the seller is deemed to consent to those changes and mandated by the underwriting guidelines. So what this really all entails is, if you find out, if you're working with a buyer and you're binding under the RE forms, and you find out that the lender has not sent out those TRID disclosures, the first thing that has to happen is the buyer has to send a notice to the seller saying, look, we can't close on we can't close on April 30th. We are going to have to close on May 7th. The seller then has 3 days after getting that notice from the buyer to say, nope, not doing it, I terminate. If the seller does not terminate within those 3 days, then basically the new closing date is whatever came across in that notice, which in my example would be May 7th, and everybody closes May 7th. So it's not a unilateral extension. It is a seller unilateral right to terminate. And if the seller chooses to not terminate, then you close on whatever date came across in that notice. All right, I've got 11:15. I think now is a good time for a break. You guys ready for a break? I am. All right, I've got 11:15. Let's come back at 11:30. When we get back, I will answer any questions and we will knock it out. We go for another hour, basically, and we will finish up everything. When you come back from break, once again, please type in your name, your email address, and your real estate license number. And everybody be back at 11:30. And I'll see you in a little bit. All right, we're going to get back started. So let me share my screen. Get rid of that. Oh, make that small. Let me ask you guys a question. In the chat function, which is easier for you guys? Is it easier for you guys for me to actually go through the contract forms and kind of go through what I have underlined and just talk about it? Or do you guys prefer the PowerPoint presentation where I've got just a blown up cut and paste? Type in the chat function, which is easier for you guys to follow along. Just put slides or forms. Forms, PowerPoint, contract, PowerPoint with highlight, slides, PowerPoint, PowerPoint. Okay. All right. I'm getting a little of both, but most have been the slides. Okay. I think what I'm going to do, thank you guys so much. It's teaching contracts through this virtual is a little bit just different. I think what I'm going to do, what I've been doing, I think I'm going to do the PowerPoint because it has spelled out, written out the points I'm making. And then every now and then, I think I'll flip back and show you contextually where it is in the form. Because the majority of you guys are saying PowerPoint. Okay, thank you so much for that feedback. I appreciate that. So we have just continued with all of the appraisals. So in the actual, we're back on the standard terms, just to remind you guys where we are. We're on the standard terms, and let me hide this notification. We're now under paragraph 7. So let me go back to our PowerPoint and go back to the slides. All right, thank you guys so much. That does help a lot. The feedback helps a lot, what you guys, how you learn, how it makes more sense to you guys to learn these contracts. So again, we just finished up with the contingency, and here is what I said. And again, you guys, I'm going to give you guys, we will email you. Dawn Southern, who is a broker in our company, is going to email you guys all the handouts. So not only are you going to get handouts of the forms with all my red underlines, but you are also going to get a PDF handout of these slides. So you'll have all the points written down too. So this is what we had just talked about under, okay, that was the seller financing. Okay, actually it's good that I came back to the slides. So let me back up just a little bit. Seller financing. Remember we said if a buyer's earnest money is going to be protected, if a buyer cannot convince a lender to lend them the money and they have to terminate based on that, the seller has given them X number of days from the binding contract to convince a lender to lend them the money. If they can't do that within that time frame, then they can terminate the contract and get their earnest money back. Their earnest money is protected. However, they have to prove that they can't get a lender to give them the money with a loan denial letter. But the loan denial letter is very specific in what can be denied. And if the loan denial letter says that the buyer doesn't have their down payment money or closing costs, no, they're still not going to get their loan and they're going to have to terminate the contract. But that does not meet the terms of the financing contingency. So their earnest money is not protected. They will lose their earnest money. Same thing with all those other examples. But because this is in the financing contingency, some of you guys work with buyers that are getting down payment assistance from some sort of grant program, whether that be Georgia Dream or whatever down payment assistance program is out there that your buyer is getting their down payment from. If they do not, let's say your buyer's getting Georgia Dream funds for their down payment. If they don't meet the terms to get their Georgia Dream money, they're not going to get their financing and they're going to have to terminate. But guess what? Their earnest money is not protected because it says right here, the loan denial letter cannot be based on not having sufficient funds for their down payment. Therefore, this is very important. This is true for GAR also, you guys. If you're working with a buyer getting down payment assistance funds, you absolutely must include this as a special stipulation in your purchase and sale agreement. Their financing contingency will not protect their earnest money if they don't get their DPA money. This agreement is contingent upon the buyer's approval for the receipt of down payment from blank program. That would be like Georgia Dream program within blank days from binding agreement date. Should the buyer not be approved for the down payment assistance program within this time frame, buyer may terminate without penalty if the buyer notifies the seller in writing and provides the down payment assistance denial letter. Again, this is for anybody getting down payment assistance funds, regardless if you're binding under GAR or RE. All right. Then we talked about that. All right. Now let's talk about, okay, I'm up to the FHA loan contingency exhibit. So again, remember we said red tape if it's a government insured loan. So let me show you actually what the FHA exhibit looks like. It is an exhibit. It's a 2-page exhibit. It says FHA loan exhibit. It has all the information that is required by the FHA if a buyer is getting FHA insured funds. The only thing, however, that you do not see on the exhibit in and of itself is there is no time frame for the financing contingency. Why? Because the time frame for the financing contingency is back here on the purchase and sale agreement. All right. All right. So now let's look at the FHA loan exhibit, and it is very consistent with an FHA loan exhibit for those of you familiar with the GAR contract. But I want to point out, see where it says in bold at the very beginning, the terms of this exhibit shall control over any conflicting language. That means you cannot write a special stipulation that negates or counters anything in an FHA loan contingency exhibit or a VA loan contingency exhibit. And basically, the first paragraph is the appraisal paragraph. And it says the buyer shall not be obligated to complete the purchase of the property or incur any penalty by forfeiture of earnest money if the if basically the FHA, if the appraisal comes in saying that the appraised value of the property is less than X, and that would be whatever your contract purchase price is. In other words, if the buyer's getting an FHA insured loan and the appraisal comes in low, the buyer may terminate the contract and will get their earnest money back. No penalty if a low appraisal. Then, just like any FHA exhibit, you fill out the information about the FHA mortgage insurance premium, and you're going to get this from your buyer's lender. And if it's added into the loan amount or if it's paid in full, most buyers are rolling it into their loan. And then it talks about FHA mandated repairs. If the FHA appraiser mandates repairs, the seller agrees to pay the repairs as long as they're not above X amount of dollars. If the repairs that the FHA appraiser mandates are above whatever dollar amount that is negotiated, the seller may terminate the contract and the buyer will get the earnest money back. Additionally, on an FHA insured loan, the seller is required to pay any tax service fee, and that may already be included if they're making a contribution to the buyer's closing costs. And same thing, if mandated by the FHA, the seller is required to connect the property to public water and public sewer as long as that cost does not exceed this dollar amount. If it does, the seller may terminate and the buyer would get their earnest money back. And there can be a septic tank or well inspection if it's required by the lender. And again, those are all things that are consistent with an FHA loan exhibit because those come down from FHA. Those are FHA guidelines, underwriting guidelines. And then it says buyer and seller warrant that this contract is an arm's length transaction. What that means, a lot of agents get arm's length transaction and material relationship confused. When you have to disclose a material relationship, that is the relationship between you as the agent and any of the public people involved, the buyer or the seller. The arm's length transaction disclosure is any relationship between the buyer and the seller. So the buyer and the seller in an FHA loan, you have to describe basically if there's a material relationship between those parties, yes or no. That's what the arm's length is. And then the VA loan contingency exhibit is very similar. The very first paragraph is the appraisal paragraph. And it does state again, buyer shall not incur any penalty by forfeiture of earnest money or be obligated to complete the purchase if the VA, if the sale price, the contract price is more than what the VA calls reasonable value of the property. In other words, if the VA appraiser appraises the property and it's less than sale price, the buyer may terminate and they will get the earnest money back. Now, I will tell you again, this exhibit and the FHA exhibit, it has the verbiage that they shall control. So even if you have, this is a little bit confusing, but even if you have an appraisal contingency time frame here, X number of days, let's say this appraisal contingency is 21 days from binding agreement date. And let's say your buyer is getting a VA insured loan. The VA appraisal comes out and it's less than the sale price. Remember, we said exhibits supersede the purchase and sale. And the FHA and the VA exhibit, they control, so you can't write a special stipulation changing that. That means that if a buyer is getting an FHA insured loan or a VA insured loan, and the appraisal comes in low, the buyer has the option to terminate and get their earnest money back through day of closing, because there's no time frame on these exhibits, and on a low appraisal, the FHA and the VA loans supersede the purchase and sale agreement. And again, that is also true on parties binding under a GAR contract. Buyer's earnest money is protected if they terminate prior to closing on a VA or FHA insured loan. Now, they can't just fail to show up to closing. If they just don't close, then they're in default, but they can terminate on a low appraisal. And then it goes on to talk about the VA funding fee, who's paying it at closing, buyer or seller, how much is it, or the buyer's responsible for the VA funding fee, so forth and so on. If you are unfamiliar with any of that information, then you need to have a really good conversation with your buyer's lender to understand what those costs are, and the buyer should absolutely understand what those costs are and what those fees are, and if they still have their funding fee eligibility or not. That is a VA issue that your lender and your buyer should know from their status being a veteran. And then again, there are, if the VA appraiser mandates repairs, the seller is on the VA appraisal, the seller is obligated to complete those repairs prior to closing as long as they don't exceed whatever dollar amount you negotiate here. If so, the seller can terminate and buyer will get their earnest money back. Same thing with the hooking up to public water or sewer and so forth and so on. All right, now we are is that true of a regular mortgage is not appraised? No, if a regular mortgage, if it's a conventional loan and it does not appraise, then the buyer must terminate prior to this time frame. It does not go through day of closing. The day of closing protection for a buyer to terminate is only on a low appraisal, is only if they're getting an FHA or VA loan. If it is a conventional loan, the buyer must get the appraisal done and negotiate through it if possible. But if they're going to terminate, they must terminate prior to this time frame. That protection of coinciding with the closing date is only on FHA or VA. Good question. All right. Condition of property. This says the buyer and the seller. You guys, this is a protection for you guys as agents. This section and the next section on brokerage. Buyer and the seller have been advised and expressly acknowledges their obligation to conduct a thorough investigation or to obtain independent professional advice with respect to any concerns they have regarding the contract or the condition of the property and the surrounding neighborhood. Now, this gives some examples. It says basically the buyer and the seller. It has seller in here because you don't want a seller. If you have a listing appointment and you do comps with the seller, and the seller, you think that the seller, based on what the house should sell for based on a CMA and what their payoff is, and it says, they should net X amount of dollars, and then you go under contract and then they end up netting Y amount of dollars. This is saying it's up to them to determine any financial advice or legal advice, so forth and so on. If you're working with a buyer, look, it is your responsibility to check out the property and the neighborhood. Check it out for the roof, for the zoning, for the survey, so forth and so on. Georgia is what's called a caveat emptor state, meaning the burden is on the buyer. The obligation is on the buyer to make sure that the buyer is completely satisfied with the property before exchanging money for goods or services. And the buyer and the seller have an obligation to get independent advice regarding their concerns with respect to the contract, including finding out if it's in a floodplain, if they're going to need flood insurance, again, zoning, survey, termites, so forth and so on. Now, it does address repairs. Buyer and seller may negotiate repairs on an amendment during the buyer's right to terminate. If they agree, if the seller agrees to do repairs, it says that they must be done in a good and workmanlike manner, completed 3 days prior to closing. Additionally, it says that the property at closing must be in the same condition as it was on the binding agreement date or acceptance date, normal wear and tear accepted, and it needs to be in broom clean condition with all garbage, debris, and personal property removed. If there is major substantial damage to the property prior to closing, then the seller can either restore the property back to the condition it was before closing, or the buyer can terminate, or the buyer can go ahead and close, and the seller would be obligated to transfer any and all insurance proceeds to the buyer. And you're like, gosh, Dana, why on earth would somebody do that? Well, there are some buyers that are buying a property that they were going to redo the house anyway, or they're buying it just for the land and they were going to tear it down anyway. So there's a variety of reasons why a buyer might still want to proceed with the closing, even if the house is substantially destroyed. All right, then we go on into the brokerage section. And again, this is more protection for you guys as agents and your brokers. It says all parties acknowledge that no broker in this transaction owes any duty to a public buyer or public seller more than what is set forth in the brokerage agreement, which would be the listing agreement or the buyer brokerage agreement, or per Beretta law, which is brokerage relationships and real estate transaction, OCGA 10-6A-1. And it also goes on to say that the seller and the buyer both affirm that they are not party to another brokerage agreement. In other words, they have not signed a buyer brokerage agreement or a listing agreement with another broker or agent, where that other broker or agent can come back and potentially get commission from them. Can the seller still request or insist the property sells on contract price if appraisal comes back lower than contract price on an FHA loan? The answer is no. We're back to the appraisal question. If a buyer is getting an FHA loan or VA loan or conventional loan for that matter, and there is an appraisal contingency in there, the seller cannot make the buyer buy it at that price. The seller went into the contract making it subject to the property appraising for that contract price. So the buyer has the right to terminate and protect their earnest money back if the property does not appraise for that price, as long as they do so per the terms of the contract, which has to do with the timeframes and the notices set forth. The seller can't, now the buyer can pay cash for the difference, but the seller agrees that the contract is subject to a third-party appraiser appraising the house for that price. All right. Hope I answered your question, Galaxy. No, that's your thing. I hope I answered your question. All right. Now I want to go on to say that this agreement, if the party is not represented by a broker, then they are a customer. In other words, they have not signed a buyer brokerage agreement or a listing agreement. That means they are a customer and they have full responsibility for protecting their own interests. Again, we talked about this at the very beginning. A client relationship is created by the public person signing a listing agreement, a buyer brokerage agreement, and these are the RE forms. The customer relationship is described in the RE form. For the seller, it's the seller's authorization to show property without a listing. For a buyer, it's the acknowledgement of the customer. And all of these documents describe compensation. All right. It goes on talking about, again, this is more protection paragraph for you guys as agents and your broker. It just says that the broker is not an expert in any matters relating to the condition of the property or the neighborhood. And you have given no advice nor made any representations in regard of any of these issues that the buyer or seller have relied on. The parties have not relied on any advice or representations. Broker has no liability for perceived advice. If there is liability, then it is limited to the amount of the commission. And then this goes on to describe dual and designated agency, which we again talked about at the very beginning of class. Now let's talk about default. What happens if a party defaults? Well, this got changed in 2019 on the RE forms. Buyer's default. If the buyer defaults on a contract, in other words, they fail to come to closing or they terminate outside of a time frame of a contingency, that would constitute a buyer default. The sole remedy for a seller is the earnest money. What that means is the seller cannot go and sue the buyer for damages. They can't sue the buyer because they've already moved out and they're staying in a hotel, or they incurred costs with the repairs they made. The seller agrees that if a buyer defaults on a contract, they agree to the earnest money and that's it. Likewise, if a seller defaults on a contract, the buyer, the sole remedy for a buyer is the buyer can say, so in other words, the seller just terminates for no contractual reason. And let's say they go on to accept another contract, whatever. The buyer has one of two options. They can either get their earnest money back and go on and find another contract, go find another house, or they can sue the seller for what's called specific performance. That means you go to court, you hire an attorney. There's a couple things you have to do first to prevent the seller from selling the house to somebody else. And it's a lawsuit. And if the buyer wins, the judge makes the seller go through with the contract. The buyer doesn't get the house for free. They still have to perform on the contract. But likewise, the buyer may not sue the seller for their inspection money, their appraisal money, their moving money, the fact that they have their stuff now in storage. They agree that they have one of two options. They either terminate, get their earnest money back, or they sue for specific performance. If they're going to sue for specific performance, they don't get their earnest money back because it's still tied up in this contract until the lawsuit is heard. Now, don't get me wrong. Anybody can sue anybody for anything. But when it goes to court and the seller has an attorney, the seller's attorney is going to say, look, buyer, when you went binding under this contract, you agreed that you're not entitled to damages. Here's your signature. So, you hear all kinds of people saying the seller just terminated and bailed on the contract. I'm going to sue them for all the money I had in it. You can't do that. They agreed that if the seller defaults, they're either get their earnest money back or they're going to be engaged in a lawsuit. I have a YouTube channel called Real Estate Made Crystal Clear. My target audience are all agents in the state of Georgia, and I cover both the RE forms contracts, the GAR contracts, license law, and realtor ethics. The reason I'm bringing this up is I have just released a video this week on suing for specific performance and all of the legal steps that have to happen before that point to prevent a seller. If a buyer does want to pursue a seller legally for specific performance, there are certain things a buyer must immediately do, again, to prevent that seller from selling the house to somebody else. Because if a judge awards specific performance, that means the seller has to go through with this contract and sell the house to the buyer. So I'm not taking time in this class to go over all of that now, but that is fully explained in like a 15-20 minute video on real estate made crystal clear. Okay, back to the question really quickly. What about a lower price? Yes, if there's a low appraisal on FHA, VA, or conventional, the buyer and the seller can absolutely negotiate for the lower price. And if they come to terms and agree, the seller agrees and the buyer agrees to sell it for the appraisal price, then you go through to closing at that lower price. And all of that is spelled out in those contingencies. Okay, back to where we are now. Now, if any of the party defaults, the broker's remedy is commission. The broker can pursue the defaulting party for the commission they would have earned had the transaction closed. All right, notices. When a buyer and a seller are sending notices to each other, it must be in writing. It must be signed by the party, meaning the buyer or the seller. And it can be done by hand, by courier, by fax, by emailed, or registered or certified mail. Nothing about phone. Voicemail is not considered notice. Text is not currently a legally recognized form of written communication with respect to these contracts because texts are done via a telephone. Even if you take a text conversation and put it on paper, that is not considered in writing. Now, if there is a notice sent by email, it is believed per the contract, it is deemed to have been received when the sender can prove that they sent it. And here's where it says that. Deemed received when the sender can prove that they sent it. And it must be email or fax or something in the mail delivery must be done to the addresses on the signature page of the purchase and sale. So in other words, if your contract prints your email address on the purchase and sale agreement and you change where you're doing business, you have to give the other party, you have to notify the other broker within 5 banking days that your address has changed or your email address has changed. All right. Then there's all kinds of things about miscellaneous provisions in the contract. One of the things I want to point out to you is this paragraph 12.7. Unless expressly agreed otherwise in the contract or otherwise provided for, the provisions of the contract shall survive closing. What that means is the parties' obligations per the contract continue after the closing if those obligations were not completed prior to closing. This is a huge difference between the RE forms contract and the GAR contract. In the GAR contract, there are only 6 things that survive closing. Commission and warranties of the seller, condemnation rights, proration rights, and anything the parties agree shall survive closing. In the RE forms contract, everything survives closing. The reason this is such a huge difference has to do with repairs. In the RE forms contract, if there is an amendment addressing repairs and the seller has agreed to perform certain repairs, and you go to closing and the seller has not done those repairs, number one, the buyer does not necessarily have termination rights. But even if you close, the seller is legally obligated to complete those repairs because of this paragraph that all the provisions of the contract survive closing. In the GAR form, repairs are not addressed as a survival issue. In other words, if the seller doesn't perform all the repairs, buyer closes because the buyer doesn't necessarily have termination rights. The buyer cannot go back and legally pursue the seller to complete those repairs because those did not survive the GAR contract. Big difference. All right. And then we've already had a discussion about this, about what the binding agreement date is and what the time limit is without modification. All right, then it goes on to say, it goes on to define buyer. A buyer is everybody named in the contract. What that means is if you have more than one buyer, whether that be a couple or whether that be a number of heirs, or if there's more than one buyer or seller named in a contract, you need to get signatures of all of the parties. And notices need to be sent to all of the parties. So that's what all of that is about. All right, let's see, what time is it? All right, we're good. Now there are some, I want to cover some frequently used disclosures. Lead-based paint, EPA, seller's property disclosure, bill of sale, and community association. Lead-based paint, again, you must use it. Not only the lead-based paint disclosure that the buyer and the seller sign, but there is a lead-based paint pamphlet that the buyer must get prior to going under contract. And those are required if the home is built prior to 1978, or if there is anything in the house that is there prior to 1978. For example, you could have a modern home with an antique mantelpiece over the fireplace. If that mantle is built and painted prior to 78, you are going to need an EPA lead-based paint disclosure. Then moving on to the seller's disclosure form. Let me see if I have a copy of this to show you guys. This is the RE form seller's property disclosure statement. So the first part I'm going to talk about is this little section up here. Then it has instructions to the seller, seller statement, and then a whole bunch of yes or no or unknown questions about the property. So that's the form we're talking about. And let me go back to the PowerPoint. Basically what this says is the fact that, can you write regarding repair? Okay, before we move on, let's talk about repairs a little bit. I kind of glossed over the fact that if a seller does not perform repairs, the buyer does not necessarily have termination rights. We have some, can you write a special stipulation that all are done prior to closing? Yes. In fact, I encourage you to add a special, if you're representing a buyer and you are negotiating for the seller to perform repairs, I strongly suggest you use one of these repair special stipulations. Number one, you are going to want the repairs to be done prior to closing. Now, in the RE forms, it does say that the seller has to complete them 3 days prior to closing. You might want to make that a little bit sooner, but you need to address what happens if the seller is not going to do it. If you want to protect your buyer to be able to terminate the contract and get their earnest money back, you have to add that in. And again, this document will be emailed to you guys. We have a special stipulation that is authored by closing attorney Amy Davis of Davis and Associates. And it states, all parties agree that the repair work contemplated and agreed upon herein shall be completed not less than 5 business days prior to closing, dated of whatever the closing date is. All work shall be completed by vendors licensed in the state of Georgia through the proper state licensing board to complete the work required herein. Seller shall provide to buyer at least 5 days prior to closing evidence of vendors licensed to do repair work, invoices, and paid receipts for all work completed. Here's the important part. Should the seller not complete the work required at least 5 days in advance of closing, buyer shall have the right to either, number one, immediately hire vendors of buyer's choice and have the work completed at seller's expense to be paid at time of closing from seller's proceeds, or terminate the contract with full refund of all earnest money. So that's one option for your buyers. Here's a special stip that's already in the RE forms in the special stipulation library. Parties agree. Basically, I'm not going to read it, but basically the parties agree to escrow X amount of dollars with a holder for those repairs to be done. Now, for you listing agents, here's one that says, seller's going to say, look, I'll do repairs, but I'm not doing repairs until after I know your loan is approved. I'm not going to put the money into that if you're going to bail on me because of no loan. There's a special stipulation there. Here's a repair cost limited. A repair seller agrees to do repairs as long as they don't cost at more than X amount of dollars. Buyers to make seller to make repairs after loan approval, so forth and so on. So again, I am going to send you guys, email you this list, these special stipulations, but repairs are can be a nightmare. When at all possible, I strongly suggest that the buyer and the seller just negotiate financially so the buyer can take care of their own repairs. Okay, back to the disclosure form. Basically, it says this is the seller just disclosing to the best of their knowledge information about the house. The seller is not warranting any of the information they're putting on this document, and by no means is this document a substitute for any buyer to have any inspections done by independent inspectors. It is the buyer's responsibility to obtain independent professional inspections, surveys, environmental tests, public records, and any other information available pertaining to the property. It's the buyer's responsibility to check that out. Now, further on in this document, you're going to see some issues: security system, wall, siding, floors, oven, range, refrigerator, dishwasher, microwave, garbage disposal. All it has is the seller is acknowledgement if there's anything wrong with any of these issues. There is nothing in the RE form's personal property disclosure statement that talks about the seller leaving those items or taking those items. So if you are going binding under the RE forms contracts and you are representing a seller, you are going to want to include this special stipulation about items the seller is removing from the house, like a refrigerator. And it says, it is understood and agreed that no later than X days prior to closing, sellers shall remove the following fixtures from the property and repair any and all damage resulting from the removal of such. Items to be removed are, and that would be refrigerator in kitchen, or refrigerator in finished basement downstairs, so forth and so on. Chandelier in dining room. Should seller damage and not repair the property, buyer shall have the right to terminate, blah, blah, blah. Again, you guys are going to get copies of these slides, so you'll have these special stipulations. All right, moving on to the Community Association Disclosure Exhibit. Again, this was changed in 2019 or 2020. And bottom line is the seller is obligated to disclose all the fees that are associated with the community association, with the HOA or the management company that manages the HOA. And it's not designed to be a penalty to the seller. The issue, and the buyer is still responsible for checking out the HOA and the covenants and restrictions and rental rights, so forth and so on. The issue is, nowadays, a lot of the HOAs, or more specifically, a lot of the property management companies, will only talk to the current owner of the house. As much as a buyer is required to do this during their due diligence, but as much as a buyer does what they can to try and get all of this information, or even a listing agent or even a buyer's agent, these management companies, a lot of them will only talk to the seller on title of the house. So that's the only way we can get this information for a buyer, so they understand what fees are going to be required if they buy a house with an HOA. So again, it is not designed to punish or penalize the seller by any means. It's just because the sellers are the only ones that can get this information. So the bottom line is, the seller is required to disclose accurate fees. If what the seller puts on this form is not accurate or less than what the current fees are, at closing, the seller must pay the difference. Again, the buyer does have the responsibility to obtain the covenants and the restrictions and what's required, and to verify that buyers shall be responsible for verifying the adequacy of coverage and ensuring the buyer's belongings. Neither buyer nor broker make any representations or warranties to any association rules or covenants regarding the buyer's ability to lease the property. Again, the seller does not warrant the accuracy of the information. They're just disclosing the fees in essence. Seller's responsibility is to disclose the fees, and then if there are any changes in those fees, the seller must disclose them within 3 days of learning what those changes are. And then it goes on here to say the very last part that I have underlined under paragraph 5. Any initial fees not disclosed and all subsequent changes to the initial fees not properly and timely disclosed as provided herein shall be paid by the seller. So you listing agents, you've got to impress upon the sellers, they've got to find out what those fees are. And it has to do with the association dues, initiation fees, assessments, recurring fees, admin fees, closing letters, clearance letters, all those kinds of issues.
Do you give big?
All right. More contingency forms: backup agreement, sale or lease contingency, and just a generic contingency. So basically, if you are working with a buyer and the buyer loves this house and wants to write an offer on this house, but the house is already under contract, then your buyer is going to go in with the purchase and sale agreement, and they're going to include this backup contingency exhibit. I don't care what some listing agents are saying. Yeah, I've got 5 backups. That's not true. You can only have 1 binding backup. The reason I say that is because in the backup contingency exhibit, you must identify the buyer of the primary contract. So therefore, you can only have 1 binding backup. Now, you can have a gazillion interested buyers, but you can only have 1 binding backup. Now, it goes on to say that basically, if a buyer and a seller negotiate a purchase and sale agreement, include this backup contingency exhibit, the earnest money is due right away, but all the other contingency timeframes begin once the seller says, okay, buyer, guess what? My contract with buyer number 1 terminated. You are now the primary contract. The date that the seller gives the buyer that notice is day 0 for counting all your other contingency timeframes. Before that happens, the buyer can say, you know what, if the buyer's still in backup position, I'm not going to wait anymore. I'm going to go find another house. The buyer can terminate the backup contract and they will get their earnest money back. Sale or lease contingency. This is RE Form 251. Basically, this says the buyer's like, look, I want to buy a new house, but I have to sell my current house. So, seller, will you accept my contract and make it contingent upon me successfully closing on my new house or getting a full lease on it? That's what this is all about. And again, you have time frames that the seller gives the buyer the opportunity to get their home sold and closed. Then you have what we call a kick out. And what that means is the seller says, look, I understand that you have to sell your house first, and I'll go under contract with you, but you are still going to allow me to market my house to another buyer. If I get another buyer that I want to sell to, I'm going to come back to you and say, look, I've got another buyer I want to go under contract with, but I'm already under contract with you. If you want to stay in contract with me, then you have to remove all of your contingencies. You have no more due diligence period, you have no more appraisal contingency, and you have no more financing contingency. You are required now to go to closing, and if you do not close for any reason, you will be in default and lose your earnest money. Or if I'm gonna kick you out, then you can terminate, get your earnest money back, and I'm gonna go with buyer number 2. That's what all of this, that's what this sale or lease contingency means. Okay, I've got a question. What about bidding wars on property? I'm not sure, Cheryl, what you're asking. So if you can describe a little more, there are bidding wars on a property. So I think it was in reference to the backup. So I'm not quite sure. I'm not sure what you're asking. So if you can be a little more specific in your question, I'll try to answer it. All right. There are other forms, counteroffer form, notice of acceptance commission, and then we are going to talk about, I got a few more minutes left, termination and release. So basically, let's talk about, this is the amendment during the buyer's right to terminate period. So again, we're under contract. Let's say it's subject to a 7-day buyer's right to terminate period. The buyer is doing what they can to figure out, are they going to go through with the contract or terminate? One of the things they do is they hire an independent home inspector. There can only be one backup, 14 offers. You can have 20 gazillion offers, but you can only have one binding backup contract. But yes, you can have a lot of contract. Yes, you can only have one binding contract, and you can only have one binding backup contract, but you can have a lot of offers and a lot of interested parties, but you can only have one actual signed binding backup contract fully negotiated with the backup contingency exhibit. Okay, now the buyer has had their independent home inspection done, and the buyer says, look, I'm still trying to decide if I'm going to terminate or go through with it. Seller, I want you to repair the roof, replace the rotten wood and repaint it, blah, 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 blah. The seller can say, yep, I'll do it all. The seller can say, nope, I'm not doing any of it. Or the seller can say, yes, I'm doing some, I'm not doing all. Again, your buyer, their earnest money is only protected if they terminate and send notice of termination prior to the end of this buyer's right to terminate period. So there's a part on this amendment, and if your buyer has a make it or break it issue. And what I mean by a make it or break it issue is if it needs, let's say it needs a new roof. And the buyer here, this is it, amendment during buyer's right to terminate. Here's where you put in what you want the seller to do. But here's the paragraph I'm talking about here at the bottom. And let's say it's a new roof. And let's say your buyer's like, I cannot afford a new roof. I cannot go through with this contract if the seller does not replace the roof. That's a make it or break it issue. Let's say you are negotiating with a seller and you're getting close to the end of your buyer's right to terminate period and you're not hearing anything from your seller. If it is a make it or break it issue, then you're going to want to check the box that says shall. And what that means is if the seller does not sign this amendment and get it back to the buyer before the end of their buyer's right to terminate period, then this acts as a unilateral notice of termination and your buyer's earnest money will be protected. You're not going to want to do it just on reversing the polarity of an outlet or paint or something like that, unless the buyer wants to terminate on that. So again, you're only going to want to mark shall if it is a make it or break it issue. Here's where we talked about the repairs. Okay, now let's talk about terminating a contract. The termination of a contract and the disbursement of the earnest money are two completely separate contractual issues. Termination is unilateral, and the party terminating will send a notice to withdraw or terminate. There is a separate form, and it only needs one signature. Now, to disperse the earnest money, however, you need both parties' signatures. This is the notice to terminate form. The terminate, and you put the reason for termination. There has to be, so that once it's terminated, it's terminated. Then again, the disbursement of the earnest money is a completely separate issue. In the RE forms, there is a separate form. It is the RE 212. This is what you use to address what happens to the earnest money once a contract is terminated. So the RE 263 is the termination, and the RE 2 and only needs one signature. And this is the RE 263. This is the termination, the reason for termination, and it's signed by one or the other. You will also need this form to disperse the earnest money, agreement to disperse trust funds, which is RE 212. Here's where you describe who's holding the earnest money and how much of the earnest money goes to what party and at what address. This one requires both. It's called an agreement, so you need both buyer and seller signatures. Once it's terminated, the seller can go on to sell the house to someone else. What's at odds might be the disbursement of the earnest money. In the RE forms, both of these two separate contractual issues are handled on one form. In the RE forms, there are two separate forms. And again, we talked about how the earnest money, how a holder can disperse the earnest money. We talked about the 10-day letter. Talked about the 10-day letter. All right. So again, if the buyer and the seller don't agree on who gets the earnest money on this form, then one of these other things that we've already addressed happens. Basically, what happens is the holder would probably do an interpretation of the contract, send the 10-day letter, and so forth and so on, as we've discussed earlier in the presentation. Okay, moving on to some other disclosures. I suggest, I don't care who your broker is, you guys are all independent contractors. You need to use any and every disclosure form and consumer brochure and get those into the hands of your public. You want to kill them with information. I'm being euphemistically, you don't want to literally kill them, obviously, but you want to be able to demonstrate that you have given them as much information as possible so that they can make an informed, consented decision. So the RE 140 is the disclosure of information on lead-based paint. This is the lead-based paint exhibit. This is an EPA guide to mold and moisture. The RE 141 is on radon. Home selling the process, home buying the process, and any and all other consumer brochures or any other disclosure forms that your broker requires that you use. Okay, you guys, we made it. We made it just in time. Again, I just want to encourage you, please confirm all contract questions with your own broker. We have additional courses if you go to registerforreclasses.com. We are still holding classes virtually, but we are going to probably in June start having them in the actual branches again. So when you go to registerforreclasses.com, you'll see a geographic area to see if there's a class offered in your area. If you click on Marietta, that will give you the master calendar of all the virtual classes. Courses are offered through the Georgia Real Estate Academy. And again, as I mentioned, this is my YouTube channel where I have 4 years plus of contract tips with respect to the GAR contracts, the RE contracts, license law, ethics. I've done a whole series of videos lately on how to help buyers and sellers navigate through this unprecedented seller's market right now. And there are buyers and sellers that need your help. So please, you have a real estate license and be a blessing with that license. Have a joyous and prosperous and healthy year helping others with their real estate needs. Now, I will stay on. If you leave, before you leave, please one more time, type in your name, email address, and license number, and I will stay on as long as anybody wants to answer any questions. But we made it. What do y'all think? I've seen a couple of comments about liking the RE forms. For those of you who have been practicing over 20, 25 years, these forms look an awful lot like the GAR forms used to look a long time ago. So any questions? I'll be more than happy. If you are more than welcome to unmute yourself to ask a question. If you are not asking a question, please keep yourself muted so we can hear all the questions. Or you can type it in the chat, whatever is preferable to you. It's so funny to me at this point, everybody stays on because everybody wants to hear everybody else's questions. No questions? I usually get, are we going to receive? Yes, I'm going to email you copies of everything. Thank you. You're welcome. I usually receive the question, what about the mixy-matchy of contracts? Can you have some parts from the RE forms and some parts from the GAR forms? The answer is, Gary, I'll answer your question in a minute. The answer is yes, as long as one doesn't conflict with something else. And what I mean by that is, for example, we talked about if the parties go binding on the RE forms, there's no 8-day unilateral right to extend the contract, right? We talked about that. So let's say the parties are binding under the RE forms. Let's say one of the parties uses the GAR amendment to extend the closing date. Well, there's verbiage in the GAR amendment to extend the closing date that says the 8-day unilateral right to extend the contract is still part of the contract or is not. Well, that has no bearing on it because there is no 8-day unilateral right to extend the contract. So that has no bearing on the contract if they're binding under the RE forms. But remember, I told you the temporary occupancy agreement for the seller after closing. In the RE forms version, it has a part in there where the seller pays the buyer at closing a certain amount of money for the privilege of staying in the buyer's house now for X number of days. That's not in the GAR forms temporary occupancy agreement. So sometimes we'll see contracts where we have buyers and sellers binding under the GAR purchase and sale agreement, but they'll use the RE forms exhibit for temporary occupancy because it has that usage fee. If you're representing a buyer, you're going to want the buyer to be compensated for giving the seller the privilege of staying in their house for a few days. If you're representing the seller, you don't want your seller to compensate the buyer for staying in the house. So it depends on which party you're representing. Gary, you had a question and I saw it went by quickly. What is my advice on using GAR versus RE forms? And again, a lot of people refer to the RE forms as FMLS forms. I'm not sure why, because they're accessible through FMLS and through Transaction Desk and Georgia MLS. But I know in our marketplace, they're referred to as that, but I have no idea why. FMLS is not the author of them. It is a closing attorney. So thank you, Pamela. I appreciate that compliment. My advice is it depends on, I'm so happy you GAR agents, you agents that are way more familiar with GAR are taking this class. It is your responsibility, in my opinion, to be familiar with any contract, whether it be GAR, RE, new construction, HUD, Fannie Mae, Freddie Mac, investor, closing attorney, to understand the basic tenets of that contract to be able to describe them to your client. Bottom line, it's your client's choice. And a lot of times your client will not have a preference. Well, now I pointed out some of the differences, but there are both of these contracts, both the GAR and the RE forms contracts are designed to protect you as the agent and your brokers. With respect to the buyer and the seller, they are both pretty even in terms of protections or representations. It just depends. For example, there's certain things I like about GAR. There's certain things I like about RE. I love the fact that the whole contract in RE survives the contract. I like the fact that there's no 8-day unilateral. I as a broker, am not happy. I'm not fond of the 8-day unilateral right to extend. If you're the parties agree to a closing date. If you're going to extend, I think it should be done by agreement. But there's parts of the GAR contracts I like better. As a broker, I would suggest to an agent to understand them all, describe them to the buyer, and then have the buyer your party make the decision which contract they want to use, which is better for their purposes. So And after that, I'm just going to ask you to refer to your own broker. I will say that you must present all offers if it's presented to you on a GAR contract, if it's presented to you on an RE forms contract, if it is presented to you on a, the proverbial cocktail napkin that we've all heard from pre-license school. A broker that says they prohibit RE anything other than a GAR form, I mentioned at the beginning, that means y'all aren't writing new construction on a builder's contract. That means you're not accepting a closing attorney's contract. That means you're not accepting a HUD contract. So I would question that and be careful because it's your license and you are the independent contractor that must present all written offers. So I would be cautious about that. My thoughts on using STIPs and standard terms from the RE by adding to other exhibits. I don't understand that question, Gary. You can unmute yourself and ask if it'd be easier than typing. Some of the special stipulations from the RE forms library, can you use those if you're binding under a GAR contract? Is that what you're asking?
Yeah, I forgot about the microphone here.
That's okay.
So yes, since the RE form does attach it at the top, the initial at the bottom, can we simply point to the STIPs or the standard terms in a GAR form and thereby attach them as an exhibit?
The standard terms have absolutely nothing to do with the GAR. They're completely separate. The standard terms is just the legalese describing the promises, obligations, and consequences of the purchase and sale agreement for the RE forms.
Right. And while the RE forms may include them, reference them, point to them, what if we were to use the GAR form but still point to them through special stipulations or exhibits?
What would you point to? I don't understand what you're asking. There's nothing to point to.
Well, at the bottom of the RE 100, it has buyer acknowledges, initials, the standards, standard terms, and I don't think the GAR form does.
The standard terms have nothing to do with the GAR form. They're just, it used to be all one document. The RE forms contract used to be all of that, all of those paragraphs spelled out. It has nothing to do with the GAR. They're not special stipulations. They're describing the fill in the blanks. They're not special stipulations.
I see. In my head, I was thinking the terms and what they should understand a contract may include are referenced, and if the other one doesn't reference it, should
no, they are describing the RE form contract. For the GAR, all the descriptions of their promises, obligations, consequences for failure to perform are described in the GAR contract.
They're in there. Gotcha.
They're already in there. Yes. Yeah.
Thank you.
Now, because they're different. They're two completely separate contracts, but the GAR is all described in the body of the GAR purchase and sale agreement. Now, what you can do, though, is if there are some special stipulations in the RE forms library that you like, you can pull up those special stipulations and use those special stipulations in a GAR contract. Likewise, if you guys have access to the GAR contracts, but your parties go binding under an RE forms contract, but you like something, you like a special stipulation in the GAR library, you can add that special stipulation as a special stipulation. But no, the standard terms is, in essence, it's easier if you think about it as one contract, which is what I'm encouraging you guys to do. The GAR form has all of that stuff described in the body of the GAR purchase and sale already, describing their fill in the blanks.
Okay.
Because they have different.
Why I'm here. Know your contracts, right?
Yes, exactly. But that's why you're taking classes. All right. Anybody else? All right. Everybody just wants to hear more. Thank you guys so much. I appreciate everything. This is a wonderful, exciting, interesting market. There are still buyers actually getting houses. There are lots of listings selling. Again, this is just, I've been practicing over 25 years, never seen anything like it. Just like we've never seen anything like what happened in 2008. That was at one part of the market cycle. Now we're at the other part of the market cycle. So it's very interesting. With all of this confusion and a lot of misinformation out there in the media and Facebook and Twitter and everything that's going on with respect to housing, your public needs you more than ever. So I encourage all agents, regardless of who holds your license, to get as informed as you can, especially on the contracts, on the market. Talk to your lenders, talk to your closing attorneys, and then go out there and help people. They need a knowledgeable, professional expert to help them navigate this crazy market. And so of all times, and with Zillow, don't get freaked out by Zillow being a brokerage and all that kind of stuff. People need personal touch. Buying a house and selling a house even is extremely emotional. You know, there are investors and they have their place, but for an actual person that's living in a home, it's very emotional and it's a big deal. And so they need that personal touch and that human interaction more than ever. So you guys are needed more than ever. Looking at all the quotes. So that's it. I appreciate your time. And I wish you guys all the best of luck. And I look forward to I see a lot of familiar faces and a lot of new faces. So thank you for coming back to the familiar faces, and for the new faces, welcome. And I look forward to seeing you in another class really soon. Thank you guys so much.
Thank you.
Bye, everybody.